Judicial immunity, a cornerstone of the American legal system, has evolved through a series of court cases into a robust shield that protects judges and public officials from civil liability, fostering a self-perpetuating cycle of impunity that undermines public safety and accountability. This doctrine, entrenched by precedents such as Bradley v. Fisher, 1871, and Stump v. Sparkman, 1978, grants judges absolute protection for judicial acts within their jurisdiction, even when those acts are negligent, malicious, or enable catastrophic outcomes, such as the murder of Iryna Zarutska, a 23-year-old Ukrainian refugee, by DeCarlos Brown Jr., a black repeat offender released by magistrate Judge Teresa Stokes in January 2025 for a misdemeanor in Charlotte, North Carolina. These cases, decided by judges themselves, reveal a profound conflict of interest. The judiciary establishes its own protections, insulated from legislative or citizen oversight, attracting opportunists and ideologues who exploit this immunity to advance personal or political agendas. The absence of external checks, coupled with parallel immunities for prosecutors, police, and legislators, perpetuates a system where officials evade responsibility for decisions that harm society, from releasing violent criminals to enforcing harmful public health mandates. This essay traces the timeline of court cases establishing judicial and public official immunity, examines their roles in creating a self-protective system, exposes the conflict of interest inherent in judges ruling on their own immunity, and critiques the lack of legislative and citizen oversight, which enables a cycle of unaccountability that threatens justice. Historical foundations. Constructing the immunity shield. The doctrine of judicial immunity traces its origins to English common law, evolving through American jurisprudence to become an impregnable barrier against accountability. Key court cases have progressively expanded this protection, with judges ruling to safeguard their own profession, creating a self-serving legal framework that prioritizes their autonomy over public welfare. The timeline begins in the 17th century, but its modern American form emerges through pivotal Supreme Court decisions that codify and broaden immunity, often without external checks. 1607, Floyd and Barker. English courts established judicial immunity to protect judges as delegates of the king, ensuring decisions free from external pressures. This common law principle, inherited by the United States, set the stage for judicial independence, but lacked mechanisms for accountability, planting the seeds for self-protection. 1868, Randall v. Brigham. The Supreme Court suggested judges could face liability for malicious acts in excess of jurisdiction, a narrow view soon overtaken by broader protections. This case hinted at accountability, but failed to establish it, as judges favored immunity to shield themselves. 1871, Bradley v. Fisher. The court formalized absolute judicial immunity, ruling that Judge George Fisher could not be sued for disbarring attorney Joseph Bradley without a hearing during the John Surratt trial. Immunity applied to judicial acts within jurisdiction, even if maliciously and corruptly done, distinguishing excess from clear absence of jurisdiction. This self-authored precedent by judges entrenched their untouchability, ignoring public harm. 1967, Pearson v. Ray. Extending immunity to 42 U.S.C. Section 1983 civil rights claims. The court protected a judge who convicted black priests for integrating a Mississippi bus terminal. It introduced qualified immunity for police, reinforcing a system where officials shield each other, with judges deciding their own protections. 1976, Imbler v. Potman. The court granted absolute prosecutorial immunity for courtroom advocacy, protecting prosecutors from suits for misconduct, like hiding evidence. This decision, influenced by judicial immunity logic, expanded the protective net, with judges endorsing immunity for allied professions. 1978, Stump v. Sparkman. Upholding immunity for Judge Harold Stump's approval of a minor's sterilization without consent, the court defined judicial acts broadly, protecting even grave errors unless clearly outside jurisdiction. This ruling, crafted by judges, solidified their unassailable status, ignoring victims' rights. 1980, Supreme Court of Virginia versus Consumers Union. The court allowed injunctive relief against judges in enforcement roles, but upheld immunity for judicial acts, maintaining the doctrine's core while offering minimal external recourse. 1982, Harlow versus Fitzgerald established qualified immunity for executive officials, protecting reasonable mistakes but not clear violations, extending the immunity web to police and others, with judges endorsing a system that protects their allies. 1984, Pulliam versus Allen permitted injunctive relief and attorneys' fees against judges under Section 1983, a slight crack in immunity's armor, but insufficient for damages or criminal liability, preserving judicial protectionism. 1991, Morales versus Waco upheld immunity for a judge ordering police to rough up an attorney, reinforcing that unprofessional or potentially criminal judicial acts remain protected, further entrenching self-serving precedents. 1996, Federal Courts Improvement Act codified immunity, restoring protections weakened by Pulliam, barring injunctive relief unless declaratory relief is violated, a legislative nod to judicial self-preservation. 2024, Trump versus United States extended presumptive immunity to presidential acts, influencing defenses like Judge Hannah Dugan's 2025 case for aiding an illegal immigrant, showing how immunity spreads across official roles, with judges endorsing broader protections. These cases, decided by judges, show the judiciary expanding its immunity, forming an unaccountable fortress. Subversive forces beyond this essay's scope influence these rulings, but the focus remains on documented historical foundations, not the deeper subversion behind judicial immunity. This essay explores the timeline without delving into the underlying influences shaping these doctrines. Conflict of interest. Judges as architects of their own immunity. The judiciary's role in establishing its own immunity constitutes a blatant conflict of interest, as judges rule on cases that directly benefit their profession, creating a self-reinforcing cycle of protection. In Bradley versus Fisher, the Supreme Court, led by Chief Justice Salmon Chase, declared that judges must act without apprehension of personal consequences, a ruling that insulated their own actions from civil suits. Similarly, Stump versus Sparkman saw Justice Byron White define judicial acts expansively, ensuring even egregious errors like unauthorized sterilizations evade liability, with judges shielding themselves from accountability. This self-authorship extends to allied professions. Imbler versus Potman protected prosecutors, while Harlow versus Fitzgerald safeguarded police, creating a network of immunities upheld by judicial fiat. The absence of external oversight, legislative or citizen, allows this cycle to persist, as judges face no independent scrutiny for crafting these protections. This conflict attracts opportunists and ideologues to public office, as immunity lowers the personal cost of reckless or biased decisions. For instance, in Zarutska's case, Stokes' release of Brown, a schizophrenic with a violent history, reflects a catch-and-release culture enabled by immunity, with no fear of civil repercussions. Similarly, prosecutors like Spencer Merriweather, shielded by Imbler, failed to push for detention, while police under Harlow escape liability for oversight failures. This system draws individuals who exploit power for political agendas, such as progressive bail reform that prioritizes offenders over victims or malicious prosecutions, as seen in January 6 cases where officials targeted dissenters without consequence. The judiciary's self-imposed immunity, unchecked by external forces, fosters a culture where corrupt or incompetent actors thrive, perpetuating harm without accountability. Systemic protection. The absence of legislative and citizen oversight. The lack of legislative and citizen oversight exacerbates this impunity, as the criminal justice system operates as a closed loop, insulated from external accountability. Legislatures, themselves beneficiaries of immunity under cases like Tenney versus Brandhove, 1951, have little incentive to curb judicial protections, as doing so would risk their own. In North Carolina, where Zarutska was murdered, the General Assembly has not tightened bail laws despite public outcry, reflecting a reluctance to challenge judicial autonomy. The Federal Courts Improvement Act of 1996, codifying immunity, shows Congress deferring to judicial self-regulation, with no significant push for reform despite cases like Zarutska's exposing systemic failures. Citizen oversight is equally absent. Unlike judges who interact daily with court processes, citizens lack direct access to influence judicial conduct. The North Carolina Judicial Standards Commission, tasked with ethics oversight, is composed of judges and legal insiders, ensuring internal control rather than public accountability. This insularity allows judges to rule on their own protections, as in Bradley and Stump, without external checks, perpetuating a system where officials like Stokes face no civil liability for decisions enabling violent crimes. The COVID-19 mandates parallel this dynamic. Health officials, protected by immunities akin to Harlow, imposed masks causing respiratory and psychological harm and vaccines linked to myocarditis, with Senate hearings in September 2025 exposing the Centers for Disease Control and Prevention's fraud. Yet, no legislative or citizen-led mechanisms held these officials accountable, mirroring the judicial system's self-protection. This lack of oversight emboldens officials to act without fear, knowing their colleagues and allied institutions will shield them, as seen in Mecklenburg County's failure to detain Brown despite his 14 arrests. Reforms to break the cycle, establishing accountability. To dismantle this self-serving system, reforms must introduce external oversight and liability, leveraging the public outrage over cases like Zarutska's to demand change. Immediate actions include federal and state investigations. Petition the FBI's Public Integrity Section or North Carolina State Bureau of Investigation to probe judges like Stokes for corruption, such as her alleged treatment facility ties, under 18 U.S.C. Section 201 bribery or Section 1503 obstruction. File Freedom of Information Act requests for court records to expose leniency patterns. Ethics complaints. Submit grievances to the North Carolina Judicial Standards Commission against Stokes and Chief Judge Roy Wiggins, citing Rule 2.15 violations for neglecting public safety, demanding censure or removal. Public campaigns. Amplify Fine's September 7th, 2025 legislation through social media platforms, using hashtags like #HoldJudgesAccountable to pressure officials, as Fine's post garnered 75,000 engagements. Engage media like Fox News to highlight systemic failures. Electoral overhaul. In 2026 North Carolina elections, support candidates for district attorney and judges who pledge stricter bail policies and investigations of judicial misconduct, breaking the cycle of insider protection. Future reforms must fundamentally reshape immunity. Zarutska Accountability Act. Enact Fine's proposed law to criminalize reckless judicial releases leading to violent reoffenses, with 10 to 20-year sentences and disbarment. Extend to prosecutors and health officials for decisions causing harm, as in COVID mandates. Abolish absolute immunity. Amend 42 U.S.C. Section 1983 to allow civil suits for malicious or reckless judicial acts, limiting immunity to true emergencies. Model on Colorado's 2020 Police Immunity Reform, SB 20-217. Post-tenure audits. Create an Office of Public Integrity to audit officials' records after leaving office, extending statutes of limitations to 20 years for crimes like obstruction or civil rights violations. 18 U.S.C. Section 242. Citizen oversight boards. Mandate citizen-led commissions with access to court recordings, empowered to recommend investigations or sanctions, countering judicial insularity. Legislative intervention. Require Congress and state legislatures to review immunity doctrines, overriding judicial self-protection with laws mandating risk assessments for releases and public health mandates. Conclusion: a call for a systemic reckoning. The timeline of judicial immunity, from Bradley versus Fisher to Trump versus United States, reveals a judiciary that has fortified its own protections, creating a conflict of interest where judges rule to shield themselves and allied officials from accountability. This self-serving system, unchecked by legislative or citizen oversight, attracts opportunists who exploit immunity to advance agendas or evade responsibility for decisions that harm society. From Stokes' release of Brown enabling Zarutska's murder to health officials' unpunished COVID mandates, the absence of external checks, coupled with legislators' reluctance to curb their own immunities, perpetuates a cycle where corrupt or negligent officials thrive, insulated by precedents they craft. Fines legislation, born from Zarutska's tragedy, offers a path to dismantle this fortress, imposing criminal liability for reckless decisions and empowering citizens to demand justice. By abolishing absolute immunity, mandating audits, and establishing oversight, society can break this cycle, ensuring officials face consequences for actions that endanger lives, restoring a justice system accountable to the public rather than itself.